Thank you for joining us for today's CME presentation, reviewing hidden liabilities lurking in your practice. We'd like to introduce our speakers today, Kathy Salois and Anne-Marie Liddy, who are senior risk management consultants with our valued business partner, ProAssurance and the NorCal Group. Together, they have over 30 years experience in healthcare risk management, professional liability, and patient safety. We appreciate their time today as they educate us on identifying hidden liabilities in your practice. Welcome, Kathy and Anne-Marie.
Well, thank you so much, Sandy. This is Kathy, and I'd like to welcome everyone in the audience. Before I begin the program content, I do have a couple of quick items to review. This program has been designated for a maximum of 1 CME credit, and you should only claim credit commensurate with the extent of your participation in the activity. So as Sandy said, at the end of the presentation, you'll receive a link to complete the survey to obtain your CME. The information contained in this presentation is intended as risk management advice. It doesn't constitute a legal opinion, and it's not a substitute for legal advice. Legal inquiries about topics discussed during this presentation should be directed to an attorney. And then finally, the faculty and planner for today's program have no relevant financial relationships to disclose. So let's move right along. I would like to begin by reviewing our learning objectives and how they will hopefully support your ability to identify various types of liability exposure and assess liability vulnerabilities within your practice, to understand the types of insurance that address various exposures and appreciate the potential impact business practices may have on patient safety. And then finally, to implement strategies to minimize risk and mitigate potential damages, thereby improving your patient safety and also to protect your practice. Now, Anne-Marie and I have spent many years working in medical practices and risk management. And now we would like to share our thoughts on some of those tricky areas of risk in your medical practice that you may not have considered. And we're also going to give you some tips to help you understand how to manage these risks. So to begin with, I've organized some of these sources of potential liability into 3 specific buckets. The first one is contracts, and then people, and then the third one is regulations and other, just as listed on your slide. So this isn't an exhaustive list. It's just a way for us to talk about those liabilities that may not be so obvious in your practice setting. So let's begin with discussing contracts. A contract is an agreement that creates legally enforceable obligations between 2 or more parties. Now, a written contract is a record of the terms of the agreement. In healthcare, we have a huge variety of contracts, and these include both internal and external ones. Our first risk management tip, and I think probably the most important for this program, is not to assume. Now, this includes assuming that contracts will automatically address the duty to comply with various healthcare laws. It will address medical health standards, patient safety guidelines, or professional liability coverage arrangements. In various ways, the terms and conditions of contracts can create unanticipated risk exposures. So to avoid these exposures, you want to make sure that key language is either present or absent before the terms are accepted and the contract is signed. One risk includes verbal promises that aren't included in your written agreement. For example, someone makes a promise to a healthcare provider during a contract discussion and it's not written into the contract. It's most likely going to be difficult, if not impossible, to enforce once the contract is signed. Some of the most obvious internal examples of contracts are employment contracts and ownership agreements. External examples include independent contractor agreements, even your agreements with your educational programs for residents or students, and then business associate agreements. How about your contracts with your accountable care organizations or your ACOs? Other obvious contract examples are those with third-party carriers, also your managed care organizations and your other payers. In addition, most practices also have contracts with vendors. What about your telehealth and EMR and your professional service agreements like your accountants, billing companies, and IT support? Leases for equipment or office space are also contracts. And there are probably numerous other insurance contracts that cover your staff or your building or your equipment, and even yourselves for business exposures beyond the practice of medicine. And then let's not forget our favorite contract, which of course is your professional liability contract. These contracts can impact patient care, and I'm going to give you some examples as we move forward. A minute ago, I mentioned key language that should be present or absent. Well, this key language is often found in contract clauses. These are provisions in a contract that define the rights, the duties, and the parameters of the relationship between contracting parties. Some clauses can increase liability risk exposures, while others can decrease it. So let's talk about some examples. One of the more subtle clauses is the automatic renewal clause. It can also be called the rollover or evergreen clause. This has the effect of automatically reviewing the contract unless a notice of termination has been given. Now, these clauses will present risks to all of the parties involved, so they need to be carefully considered. Automatic renewals may not allow enough time to review or make changes to the contract. Then again, they could be beneficial when a party wants a business relationship to continue without having to renegotiate the terms every time the contract is due to expire. So an example, for example, a practice depends on a specific item from a vendor for patient care. Well, an evergreen clause will allow the practice to continue receiving those needed supplies without any interruption, and also without having to negotiate a new contract or locate an alternative supplier. Another challenge with evergreen clauses is that termination or contract revision could be more complicated if it's difficult to determine what constitutes that reasonable notice. So for that reason, contracts with automatic renewal clauses should provide explicit requirements for termination or revision, and also make sure they set a definitive time frame for providing notice. When a practice enters into a contract with an automatic renewal clause, you should set up an alert so that the provisions of the contract can be reviewed at least yearly, but definitely in advance of any required notice of change or any cancellation date. Another example of a potentially risky contract is the indemnification or hold harmless clause. Now, indemnity clauses appear in a wide variety of healthcare contracts. And generally speaking, to indemnify or to hold harmless means that you are agreeing to assume another party's risk. Indemnification clauses in a contract can shift that liability to the healthcare provider who signs the contract, even when the damages or injuries were caused by another party. So an example would be when a physician signs a contract to join a medical group, the physician may be agreeing to take that responsibility for the group's malpractice liability if both of them are named in a lawsuit. Now, if a patient files a malpractice case against that physician and alleges a vicarious liability, which I'll discuss more in a little bit, against the physician's group, and the physician signed a contract agreeing to indemnify the group, then that physician may have just agreed to pay for the group's attorney fees, the court costs, the verdict, and even the settlement. The words hold harmless and indemnify, they don't have to be in the contract clause to create a duty to indemnify, but often they are, so keep your eyes open for that. In general, malpractice insurance policies don't provide coverage for those indemnification agreements. So for example, NorCal, like many other policies exclude any liability that an insured has assumed under a written or oral contract or agreement, with very few exceptions. So consequently, in many cases, indemnity agreements create an uninsured risk for you, for the physician that has signed the agreement. Now, frequently, contracts will appear to make liability obligations mutual. So, for example, the group may also agree to indemnify the physician, but given the nature of malpractice litigation, the onus is much less likely to fall to the group. So in other words, plaintiffs will rarely allege primary negligence on the part of the group and then claim that the individual physician has vicarious liability. It could happen if the negligent act was entirely on the part of the staff member and the group and the individual physician have been named. So physicians should be wary of signing contracts containing the terms indemnify or hold harmless or any similar language, and you should definitely have any contracts reviewed by a qualified attorney. Also, be sure to review liability policies for exclusionary language that may apply with any contract that you're considering. So I'd like to review a quick case study, and it may or may not be applicable to your practice, but it's a good illustration of how this situation could apply. And an emergency room department was part of a group that contracted with a hospital to provide emergency medicine services to patients. Well, within the contract between the group and the hospital, there was an indemnification clause. At one point, the ED physician failed to diagnose a patient's condition, and that resulted in the patient sustaining significant injuries. Well, the patient filed a lawsuit against the ED physician, against the group, and the hospital. Now, the hospital demanded, pursuant to its contract, that the group indemnify it for any costs associated with defending the lawsuit. The group's liability insurer refused to indemnify the hospital based on an exclusion in the group's insurance contract. And this exclusion stated, "We will not defend any claim, nor will we pay any damages, defense costs, or additional benefits for a claim arising out of, directly or indirectly, any liability that an insured has assumed under a written or oral contract or agreement." The group's governing board was also unaware that they had agreed to pay for the defense of the hospital as a result of the indemnity clause. They had not made the connection, right, between the indemnity clause in the contract and the exclusion in their medical policy. The group was pretty surprised to find out that their organization's assets could be at risk. Defense costs and indemnity payments were not covered by insurance, and that could force the group into bankruptcy. So the fear of bankruptcy put the group in a very weak position when it became time to consider whether or not the case should be settled. Let's move on to another type of clause, and this is the Certificate of Insurance, or COI clause. An outside contractor who has inadequate insurance coverage could really place you or your practice at a greater risk for exposure. So you definitely want to obtain a certificate of insurance to verify adequate coverage for any of your outside contractors. If a contractor that your organization hires is negligent in performing its duties and the result is a patient or visitor injury, ideally the contractor's own liability insurance will cover its negligent acts. However, if the contractor is not insured or could be underinsured, your organization is likely to be held financially responsible for either some or perhaps all of the damages. So a COI would be a good way to assure that a contractor has proper insurance coverage. The proof of insurance clause in a contract requires, among other things, that the party provides a COI. Now, I know that all of you deal with this routinely when you provide your COIs to hospitals and insurance carriers for credentialing. So I know you're aware of it. The other party's COI should be reviewed for insurance coverage appropriate to the circumstance. So you want to make sure that you review the recommended limits for each type of policy in conjunction with your legal counsel, because you want to make sure that they are ideally consistent with the limits of coverage that your own organization carries for that particular risk. And then you don't become the deep pocket. Now, don't forget to monitor the certificates for expiration dates, proper coverage, and limits, since they could also change at the times of renewal. Okay, let's talk real quick about managing and maintaining contracts. And I'm sure this is nothing you haven't heard before, but the worst possible time to learn that someone in your practice has entered into a contract is after a lawsuit has been filed. So every practice should have a current list, of contracts. And on this list, you should include the name of the individual that signed the contract and whether a COI is on file. You should also note the dates that the contracts are due to expire, or otherwise note a review date. All contracts should be kept together in a central file or location. Okay, let's move on to one of the most obvious liability exposures in your practice, and that is your people. Human resource or human capital management, that includes not only your employees, but also any healthcare professionals who provide services to your patients within your practice, or it could be even if they're perceived to be connected to your practice. And that is a vicarious liability, which I'm going to discuss in detail in a moment here. So think about this. Have you ever said or heard someone say, hey, but it wasn't me, and I don't even know what they were doing. I didn't know they were doing this. Or how about, I wasn't involved in that, so why am I a part of this? Well, if only things were this simple, right? When we think of medical malpractice liability, we generally think of those situations directly involved with the provider, like a misdiagnosis or an adverse event that resulted in a poor outcome. Although liability risks can result from those types of direct interactions, they can also be from indirect sources as well. And that's your vicarious liability. So in the next few slides, I'll review how others' actions can lead to these unwanted liabilities. But first, I'd like to start with some very basic concepts. So vicarious liability refers to a situation where someone is held responsible for the acts or omissions of another person under the common law doctrine of respondeat superior, which is Latin for let the master answer. It says that a principal or employer can be held vicariously liable for the acts of an agent or an employee that are committed within the course of employment. A principal or employer can be held vicariously liable not only when a formal partnership agreement exists, but also if a plaintiff can prove that an ostensible, meaning an apparent or a perceived, agency relationship exists. So basically, your ostensible agent is a person who reasonably appears to be the agent of another. Did you know that exposures may exist simply because you employ people in your practice? While the specific definition may vary by state, in the most general sense, vicarious liability allows an injured patient to hold a third party financially responsible for the negligence of the person who caused the injury. So, in other words, physicians can be held vicariously liable for the negligent acts of their employees in a variety of circumstances. So one example is if a patient is harmed because of substandard care that's been provided by an employee, a physician who employs or supervises the employee can be held liable for that harm. A physician is also at risk if an employee is performing tasks beyond the scope of their practice. Now, this is really important, and this is why we always recommend careful recruiting, orientation, training, and evaluation of employees. This will help the practice reduce or avoid problems that could result in a patient being dissatisfied or harmed, and that could result in a professional liability claim. You want to make sure you have job guidelines that are consistent with training, scope of service, or practice under the staff's verified qualifications, because that will help you to reduce vicarious liability. So I'm going to go over this a little bit more in a little more detail in the next slide. And here are some other examples. So with healthcare professionals, an employer may also be held vicariously liable for the acts or omissions of its employees. And that's, excuse me, provided it can be shown that the act or omission took place in the course of employment. When a patient is harmed as a result of negligent treatment administered by, say, your medical assistant or even one of your advanced practice professionals or another employee, then the patient can bring claims against the supervising physician or the person who is supervising someone else like an advanced practitioner for not only the employee's negligence, that would be your vicarious liability, but also negligent hiring, training, and supervision. And that's a direct liability. One important thing, lack of identification, like the failure to use name badges for your employees, that can also pose a risk. And there are numerous types of healthcare providers and staff members, and they have various levels of training that all work together in medical settings. So distinguishing the different types of employees by having them wear proper identification, that provides a measure of patient awareness about what each employee can and cannot do. Now, I know when I go into a doctor's office, that's the first thing I look at. Who is putting their hands on me and what does their name tag say? Scope of practice or service may be misunderstood by a patient if the employee is viewed as someone who is able to perform certain services when they're not. So, for example, a medical assistant versus a nurse or a PA. So the reasons for identifying oneself are to represent your scope of practice accurately, and in doing so, to provide safe and appropriate patient care. It's really important that employees are not provide information to patients outside of their proper scope of practice and authority. Now, some states also require healthcare providers in the hospital and in physician practice settings to wear identification badges. And I am fairly certain that California is one of them. I'd like to review a quick case study. This again may not be applicable to your situation, but it really is a great illustration for how it applies. So a physician who owned a small group practice learned about a PA from a colleague that had previously employed the PA. So this physician brought him in for an interview. The PA showed the physician some papers, one of which appeared to be a physician assistant certification. Well, the physician assumed the paper was the PA's license, but it actually wasn't. He didn't have a license. So when a patient filed a lawsuit, or I'm sorry, they filed a medical board complaint, actually, excuse me, against the PA, that's when the board discovered that he wasn't licensed. The medical board then revoked the physician's license. Why? For aiding and abetting the unlicensed practice of medicine. Let's move on to independent contractors. There are several types of relationships that a physician or a practice group can have with independent contractors. In one situation, your independent contractor of the same specialty as other physicians in that practice may come to work within the group. They may see your patients in the same ways that your partners do. So for example, if a physician in a family medicine group takes an extended leave of absence, you might hire an independent contractor to see that absent physician's patients while they're away. That's like your locum tenens providers. Well, in an ostensible agency claim, a patient has been led to believe that an agency relationship exists, even if there's no legal partnership. Now, if the group has made document efforts to educate patients about its relationship with independent contracts and has put contracts in place that clearly define the separation of relationships, then that group is going to be less likely to experience an ostensible agency claim, and they'll also be more likely to successfully defend such a claim if one happens to be filed. An ER physician in a hospital, that's a good example of this. If the physician's wearing a hospital logo on their lab coat, then the patient may perceive that they're employees, right? Okay, real quickly, sharing resources like your office space or joint advertising, combined billing statements, that can give the appearance that a partnership exists. If your practice appears to have a partnership with other physicians or entities where no professional relationship can really exists, then this can leave you exposed to liability and an uninsured risk despite your intention of being separate. And I'm going to go over some more about sharing office space later as it relates to statutes. Here are some quick risk management tips. As you can see on the slide, we already discussed some of these, so I'm not going to bore you with reading each one aloud, but I would like to just highlight a couple that are very important. So don't rely on the hospital or the payer credentialing processes. You want to check primary sources for verification. Now that includes, as you saw, the PA's license, right? You also want to check primary sources for verification for residency programs, prior hospitals, prior groups, as well as I said, the state licensing websites. And you want to implement explicit policies for researching applicant backgrounds prior to hiring. Be sure you monitor and evaluate the people you hire to provide your patient care and confirm that they comply with your patient safety standards. Become familiar with and follow the rules governing identification of healthcare providers and employees of your practices and the facilities that are within your state. Don't let independent contractors wear clothing or badges with the practice name or logo on them. And finally, require all independent contractors to maintain their own medical malpractice liability insurance. I provided some valuable information earlier regarding contracts, and here's a quick risk management tip to recap on contracts and agreements pertaining to independent contractors. You can use this for your reference when you receive the slide deck. Okay, let's talk about laws affecting agreements to share space. Now, this again may or may not apply to your practice, but it is another noteworthy consideration about vicarious liability and how violations of federal statutes may occur when you're sharing office space with someone from outside of your organization. So let's discuss these violations, as they could be one of those hidden liabilities that are lurking in your practice. To begin with, Stark law, also known as the self-referral law, has specific rules and exceptions within the rule for leasing and subleasing space to another healthcare entity. It prohibits a physician with a financial relationship in an entity from making a referral for designated health services that are covered by Medicare and Medicaid to that entity, even if the services are billed to an individual or another third-party payer. The federal anti-kickback statute, that's a criminal statute, and that prohibits the exchange or the offer to exchange anything of value in an effort to induce or reward the referral of business reimbursable by federal healthcare programs. Examples of prohibited kickbacks include receiving financial incentives for referrals, free or very low rent for office space, or excessive compensation for, like, say, your medical directorship. So an example would be a PCP practice that advertises chiropractic services on their website. The chiropractor that performs these services is a separate business entity that leases space from the PCP practice, and it refers patients to the PCP practice in exchange for free advertising. So again, probably not a good idea. Some of the risk management tips regarding sharing office space, they're similar to the risk management tips involving independent contractors, as I discussed previously. But it is important to understand them as they relate to sharing space arrangements. So you want to make sure and clearly identify separate practices with your appropriate signs, both on the entrance door and inside the office space. And also use separate check-in areas. Do not use common letterhead, logo, or billing statements, business cards, or any common form of advertisement. So don't share your professional licensed employees nor your administrative staff, and consider developing strict policies on when patients may be seen or referred to by each physician in the office. Ensure that patients are provided a list of available like clinicians to choose from when they are referred. Be familiar and compliant with federal and state laws, and definitely contact an attorney to address the legal aspects of sharing a practice location and resources with other healthcare providers. And that's all of the information I have for you. So I would like to now turn this over to Anne Marie.
Thank you, Kathy, and good afternoon, everyone. Another area of exposure to your practice is the financial management of your business, and this can include accounting, cash management, investments, and billing for your services. So today I'm going to share with you how your billing and revenue cycle practices can be another potential area of hidden liability. So, as a provider, responsibilities include being knowledgeable and compliant with billing standards and applicable statutes. The National Healthcare Anti-Fraud Association estimates conservatively that healthcare fraud costs the nation about $68 billion annually, or about 3% of the nation's total healthcare spending. Other estimates range as high as 10% of the annual healthcare expenditure, or $230 billion. Okay, so let's move on to reviewing these billing statutes. On this slide, you'll see a list of statutes. You will see a list of statutes. Kathy discussed some of them and how it involves sharing office space, but now let's review them as they relate to billing compliance. The False Claims Act notes criminal penalties for submitting false claims that include imprisonment and criminal fines. Physicians have gone to prison for submitting false healthcare claims. So you should also be familiar with key TAM and whistleblower rules regarding false claims. So here are some common examples, and they would be billing for unnecessary medical services, charging excessively for a service or supply, or misusing codes on a claim, such as upcoding or unbundling of those codes. So, in a recent case published by the Department of Justice, stated that an ophthalmologist purchased and treated patients with unapproved, misbranded medication purchased outside the U.S. He then violated the False Claims Act when he billed Medicare for the non-covered, non-reimbursable, unapproved medication as if it were FDA approved, and he kept the difference in price as profit. Monetary penalties for $450,000 have already been issued, and criminal penalties may have been applicable in this case. The anti-kickback statute is a criminal law that prohibits the knowing and willful payment to induce or reward patient referrals or the generation of business involving any item or service payable by the federal health care programs. Besides the anti-kickback statute, the beneficiary inducement statute also imposes civil monetary penalties on physicians who offer remuneration to Medicare and Medicaid beneficiaries to influence them to use their services. An example of this would be taking money or gifts from a drug or device company or a durable medical equipment supplier. Keep in mind, this can't be justified by simply stating that the drug or the equipment would have been prescribed or purchased without the kickback. The physician self-referral law, commonly referred to as a Stark law, as Kathy mentioned, is noted as prohibiting physicians from referring patients to receive designated health services that are payable by Medicare and Medicaid from entities which the physician or an immediate family member has a financial relationship, unless an exception applies. And just so you know, new requirements on compensation models took effect on January 1, 2022. So this may be a really good time to have your attorney review your current compensation model if you offer any of the designated health services which may fall under this regulation. The exclusion statute states that the OIG is legally required to exclude individuals and entities from participation in all federal healthcare programs, when providers are found guilty of certain criminal acts. So you really should be checking this list when you are hiring a new physician, new provider, or even your staff members. So here are a few examples of payouts for violations relating to the statutes we just discussed. As you can see, the recent payouts are from $330,000 to $18.25 million. Again, billions of dollars of fraud occur annually, and the penalties are both financially significant, but they're also criminally punitive. So how does this happen? Sometimes these payouts are from acts of ill intent, but what about when they're not? Well, problems may arise, such as fraud allegations, when billing for patient care if the office staff or a third-party biller selects an incorrect code. Billing statements, as well as medical records, should accurately reflect the care provided to patients. It's extremely important that the procedures performed are the same procedures listed on the claim form submitted to third-party payers. The code you select should be based on the medical necessity, and documentation within the medical record must provide appropriate reasoning for these services. Billing personnel must be knowledgeable, well trained, and current on all aspects of medical claim handling. Improper coding can also work against the practice by resulting in lower reimbursement than was entitled, based on the services that were actually rendered. The physician is ultimately responsible for coding each visit. The use of templates and copying and pasting of information in an EHR can result in inadvertent upcoding or even just incorrect coding if the information does not reflect what actually occurred during the visit. Unbundling may occur when a misunderstanding of coding exists. So, inappropriate or improper billing, whether intentional or unintentional, can result in the allegations of healthcare fraud, the risk of monetary fines, and unfortunately, possible loss of Medicare certification. So, no matter what your business model is, laws and compliance may be applicable. Therefore, being knowledgeable can significantly reduce your risks associated with the penalties. In the event of a government or private insurance audit, having evidence of the periodic chart audits demonstrates the intention to code and document correctly. So that could help. Here are a few tips for reducing billing compliance risks. Understanding the responsibilities that you bear regarding state and federal law is a key factor in reducing risk. Make sure that any staff member that you employ and your third-party vendors are able to handle your billing services competently and with applicable skill sets needed to maintain billing compliance. Implement a compliance program that allows you to identify and correct improper payments, to respond to complaints, to monitor accounts receivable reports, and to perform self-audits that coincide with regulatory requirements. Monitoring and auditing under compliance programs are essential to complying with federal overpayment requirements. Other exposures, make sure that any staff member that you employ and your third-party vendors are able to handle your billing services competently and with I'm sorry, that was my mistake. Make sure, sorry. Now we're going to switch gears a bit. As Kathy mentioned earlier, there may be other liabilities that you may not have even thought of. One of those hidden exposures is your practice's website or social media platforms. So let's talk about some of the ways those can get you into trouble when they aren't properly managed. Physician advertising is controlled by state and federal laws and regulations. And physicians can run afoul of these laws and regulations in a variety of unintentional ways, including advertising discounts, misrepresenting their credentials and their staff's credentials, improper use of photographs, use of celebrity testimonials or endorsements, and misstating a treatment's effectiveness and safety. State laws may also allow patients to sue the physician for damages if they were injured by the false or deceptive advertising. So keep in mind that these risks and recommendations may not only apply to a company's website, but also to your patient portal and any services that are promoted there, as well as your social media platforms. So, in this next case, I wanted to discuss a physician's website stated that he was board certified. And according to the patient, she chose the physician based in part on the certification claim. Her procedure was completed without complications. However, the patient was never satisfied with the results. She ultimately underwent a revision with a different physician who told her that her first surgeon had been negligent, which is, as you know, always very helpful. The patient called her state medical board to file a complaint. During that process, she discovered that the physician was not board certified. She then filed a lawsuit alleging multiple things. She alleged malpractice, negligence per se, and negligent representation and fraud associated with the false claims of board certification. Some advertising risk management considerations are to protect patient privacy. If ads contain photographs from a physician's office, please ensure that elements of the photos don't violate any patient privacies. So, for example, if the medical records area in your photo shows a picture of the interior of an office, make sure that no patient's names are visible on the records. If patients appear in any photographs, please obtain written permission from the patient to use the pictures. And if before and after photographs are used in advertising or marketing, inform patients depicted in the photos that there is the potential for the photographs to be obtained by others and republished without their or the physician's permission. This discussion should also be documented. If you hire a marketing or advertising company, ensure that they are familiar with healthcare advertising restrictions. Use caution when advertising specialty certification. Use the term board certified as defined by the American Board of Medical Specialties or other certifying organizations and make sure they reference the appropriate physician. Please don't imply that board certification or specialty training that doesn't exist. Many physicians advertise that they are board eligible, but according to the ABMS, this term is meant to indicate that a candidate is preparing for certification and it's not intended to be used indefinitely. And also have advertisements be reviewed by a healthcare attorney. So, moving on, perhaps you haven't even considered that your website or social media platforms need to be accessible to those with disabilities. The current legal environment in the U.S. makes it very advantageous for those with disabilities to sue businesses under ADA Title III. And the ADA makes it clear that the defendant automatically has to pay plaintiff's legal fees. So a disabled user really has nothing to lose by filing a lawsuit. Most ADA Title III lawsuits find in favor of the plaintiff, and the Department of Justice, the DOJ, has made it clear that the ADA compliance includes website accessibility. But it doesn't really specify what you need to do to make sure your website is accessible. And so, although the DOJ has declined to adopt any official legal standard for the ADA, it has frequently referenced the Web Content Accessibility Guidelines, which is considered to be the best measure of web accessibility when it comes to federal law. And there is a link to these guidelines on the resources page. Failing to comply with the ADA means your business is susceptible to lawsuits, and the cost of the ADA lawsuit can add up quickly. Attorneys' fees alone can range up to tens of thousands of dollars. Beyond regulatory consequences, failure to provide accessibility to users with disabilities means losing out on business and potential sales potential sales opportunities. ADA compliance makes it easier for search engines to crawl and index your website, pushing it up on the rankings and getting your web content in front of more users. The best way to build an ADA compliant website is to demonstrate that your business has made a good faith effort toward accommodation and reasonable accessibility, and to get ahead of the regulatory curve in developing a compliant website, therefore avoiding potential lawsuits. To find out more about the ADA website compliance and how you can protect your business, you may want to consider consulting with a disability attorney. Here are some common ways that businesses can address accessibility issues associated with their web content. And this gets a bit technical, but bear with me because it may assist you in having discussions with your web designer and or your attorney. You want to create alt tags for all images, videos, and audio files. Alt tags allow users with disabilities to read and hear alternative descriptions of content that they may not otherwise be able to view. Create text transcripts to help hearing impaired users understand content that would otherwise be inaccessible to them. Making it clear what language the site should be read in helps users who utilize text readers. Text readers can identify those codes and function accordingly. If a user with a disability is encountering input errors because of their need to navigate the website differently, your site should automatically offer recommendations as to how visitors can better navigate to the content that they need. And also, menus, links, and buttons should be organized in such a way that they're clearly delineated from one another and they're easily navigated throughout the entire site. So, at the beginning, we talked about contracts and some of the hidden risks buried within them. And to wrap up today's program, I wanted to discuss some of the most confusing contracts of all, and those are your insurance policies. Most practices will have several, but chances are you may not even know what your policies say. I know personally that I don't. They are usually many pages long and they have a language all unto their own, just like medicine, so you should feel quite at home. Let's go over some of the terms that we use in the insurance business that might be able to help you to better understand what you're buying. As I mentioned before, an insurance policy is a legal contract and generally includes five standard elements. The first is the declaration page, and this is where the insured is identified and the contract describes what the policy covers and typically includes the policy limits. Following that will be the insurance agreement. This will describe the insurer's obligations to the policyholder. After laying out the insurer's obligations, there are conditions. This covers the many obligations of both the insurer and the insured. And one example of this might be how claims or incidents are reported. The base policy form may also include exclusions that apply to everyone covered under the policy, such as engaging in experimental procedures. Usually, the last components of the insurance policy will be the endorsements, which these identify both exclusions from and in additions to the policy. And this is where you would add coverage for what is not intended to be covered under the policy. Endorsements are also how insurers add exclusions for what may be thought to have been covered but is clearly defined that it is not. An easy example of this might be a life insurance policy that excludes death from high risk activities like skydiving. If an endorsement provides coverage for what is not intended to be covered, It may be at an additional cost. In a life insurance policy, they call this a rider. An example in a malpractice policy may be to endorse other office locations onto the policy that are not the insured's primary practice location. Also, you should date, file, and retain all of your insurance policies, even if they have terminated or if you receive a new version of the policy. Since the terms may change from one policy document to the next, something that may have been covered if you made the claim under one policy may not be covered if you make it again under another or make it under another one. So you'll want to have documentation of the exact contract that applied to your circumstances during that time. And you shouldn't rely on your agent or your insurance company to provide this to you. Okay, so now that we've dissected the actual insurance policy contract, I'd like to go over some terms that you may find that will definitely impact whether or not you have coverage at a given time and under a particular policy. You've probably heard a lot of these phrases over the years, so hopefully we'll put some clarity to what they mean and how they relate to one another. So, an occurrence. This is the type of policy you would usually find with property insurance, such as your auto or homeowners, and most of your business policies as well. In an occurrence policy, claims are covered if one coverage is in place at the time of the event, no matter when the claim is asserted, even if the policy has expired. Okay, so for example, you had auto insurance with Allstate in 2020, but you switched to Geico in 2021 to save some money. But you were involved in a mild fender bender back in 2020 when you were still with Allstate. Nobody was hurt, and you had real no damage to your car, so you didn't even report the accident. Now in 2021, the other driver serves you with a lawsuit for injuries they claim were sustained during that accident. If your policy was in good standing with Allstate, they will be responsible for the claim, even though you're now with Geico and you didn't report the claim to Allstate when the policy was still in effect. In a claims made policy, the claim is covered if continuous coverage is in place from the same carrier on the date of the event and on the date the claim is asserted. Of course, limitations and conditions may apply. Okay, moving on. Prior acts or nose coverage is coverage you purchase from a new carrier to cover claims that may have occurred previously when you were insured by someone else, but which you may not even be aware of yet. These potential claims are referred to as IBNR or incurred but not reported. You've probably seen on your certificate of insurance a retroactive date. This is the earliest date the policy would cover IBNR events and is also the effective date of prior acts coverage. Extended coverage reporting endorsement, or ERE, is also known as TAIL. This is the coverage you purchase from the prior carrier to cover IBNR under the previous policy. This is an endorsement that allows you to continue reporting claims even after the policy has ended. And most carriers can include a time limit to purchase tail coverage after you leave them. So, to apply this terminology in medical malpractice, if you have an occurrence policy, you will not need to purchase tail when this policy ends. These aren't so common anymore, though, because they are much more expensive since you're basically paying for that tail coverage every year when you purchase the policy. You also would not need to purchase prior acts nose coverage from the next carrier. If you have a claims made policy and you change carriers, you would either need to purchase the tail from the company you're leaving or purchase the nose coverage from the new malpractice carrier. If you do not need to purchase the tail in if you don't purchase the tail in time and you don't buy nose coverage from the new company, you will have a coverage gap, which will leave you bare for any IBNR claims, and that's probably not a great place to be. Okay, so now let's go over some other insurance terms that help to clarify what they really mean. The coverage trigger is the event that triggers or initiates coverage under the policy, and this trigger is defined by the policy. Policies may define a coverage trigger as an incident or a demand for money or even a lawsuit. What does this mean for you? Well, if your policy is triggered only by a lawsuit and you report a bad outcome, they may not set up a claim right away or assign an attorney until the lawsuit is actually filed. Carriers are different this way, so this is an important distinction to understand when you're buying insurance. An excess policy is a separate policy that you buy to provide additional coverage beyond the limits of the underlying policy. Insurance companies actually will buy excess policies for their own protection. How is this different from an umbrella policy? Well, an umbrella policy provides a single higher limit of coverage over multiple underlying policies, like an umbrella. The limits of the umbrella policy may only be applied once during the policy period. You may save money by purchasing lower limits of insurance on your homeowner's, auto, or other policy that includes liability coverage. You can then buy one umbrella policy that would only kick in if the limits of one of the underlying policies was exceeded. This allows for extra protection without having to pay higher limits on every policy, since most people wouldn't expect to have a liability claim on multiple policies in the same time period. At least we would hope not. Legal defense, inside or outside the policy limits, refers to whether the cost of defending the claim will erode or reduce the limits available to pay the award. Most malpractice policies have legal defense separate from the indemnity limits, which is the money that's available to pay the plaintiff. There are some malpractice policies that include legal defense within the policy limits, and as expensive as claims are to defend, you could find yourself with very little money left to pay the plaintiff. These are really tricky policies, so be sure you give careful consideration before you enter into this type of insurance policy. Okay, so now that we've discussed a lot of the business aspects of your medical practice that creates risks for you, we promised in our learning objectives to help you appreciate the potential impact business practices may have on patient safety. So be sure to adequately credential and or verify qualifications and skills of those providing medical care. Be sure to properly identify staff members' roles to avoid confusion regarding patient expectations with regard to their scope of practice. Be sure to properly document medical services and medical necessity, which improves coordination of care as well. Properly promote your organization through your website and social media outlets. This offers patients and potential patients information and education, and can also be instrumental in establishing realistic expectations for care and outcomes. Understanding your risks and insurance product coverage, as well as assessing your needs, may make the difference between sustaining or closing your business. This becomes evident in the wake of catastrophic losses, such as the pandemic, and major weather impacts. And it can become apparent in a more personal loss, such as a fire that destroys a medical office, its content, or its patient records. May have identified some other examples of how these risks could carry over into the quality of care provided at your own practice. If you do, please feel free to share them with us after the program in the Q&A section of the attestation. Kathy, the CME team, and I truly appreciate you taking the time to attend our program today, and we hope that you've learned something new, or at least you're thinking about ways your business could be better protected.